A federal judge just issued an asset freeze order that extends far beyond anything Trump's legal team anticipated. District Judge Lewis Kaplan signed a preliminary injunction on Wednesday morning that freezes not only Trump's personal real estate holdings, but also all business entities through which those properties generate revenue, effectively halting Trump Organization cash flow from 12 properties valued at approximately $1.8 billion. According to financial experts who reviewed the 142-page order, this is not a standard asset preservation measure that simply prevents property sales. This is comprehensive freeze authority that stops all transactions, prevents any transfers, blocks revenue distribution, and requires detailed financial reporting to court-appointed monitors, who will have access to every Trump Organization bank account and financial record. When federal judges issue asset freezes that extend to operational business entities and impose court supervision of daily financial operations, we are witnessing enforcement that goes beyond protecting potential judgments and enters territory of dismantling business operations in real time. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what triggered this extraordinarily broad asset freeze that caught Trump's attorneys completely unprepared? The order stems from the Eugene Carroll defamation case where Trump was ordered to pay $83.3 million in damages. When Trump failed to post an appeal bond within the court-ordered deadline, Carroll's attorneys filed an emergency motion requesting asset preservation measures to prevent Trump from transferring properties or restructuring business entities to avoid paying the judgment. This was not just another motion in routine post-judgment collection efforts. This was Carroll's legal team presenting evidence to Judge Kaplan that Trump had already begun transferring property interests to family members and offshore entities in apparent anticipation of enforcement actions. And believe me, when federal judges review evidence showing defendants are actively moving assets while judgments are pending and respond with comprehensive freeze orders covering entire business operations. Enforcement authorities have concluded that half measures will be insufficient to preserve judgment collection possibilities. Here is the full picture of what has been unfolding. Tensions between Carroll's legal team and Trump regarding judgment satisfaction have been escalating since the February verdict, fueled by what Carroll's attorneys describe in court filings as systematic asset transfers, sudden corporate restructurings, and what they characterize as a deliberate strategy to place property beyond the reach of legitimate creditors before enforcement can occur. But everything reached a crisis point on April 10th when Carroll's attorneys obtained banking records through subpoena showing that Trump Organization had transferred management rights for several properties to newly formed Delaware limited liability companies during the 3 weeks following the verdict. The emergency motion filed on April 10, 2026 reportedly included banking records, corporate filings, and property deed transfers that demonstrated a pattern of asset protection activities beginning immediately after the jury verdict. Sources told Bloomberg that Carroll's attorneys had hired forensic accountants who traced property interests through multiple corporate layers and identified transfers that appeared designed to make enforcement more complex. The motion argued that without immediate court intervention, Trump would successfully insulate assets from collection by the time standard enforcement procedures could be completed. Judge Kaplan scheduled an emergency hearing for April 12th and ordered Trump's attorneys to explain the corporate restructurings and property transfers documented in Carroll's motion. Smash that like button if this is making sense so far. Here is where it really gets serious. When Judge Kaplan reviewed the evidence of post-verdict asset transfers presented by Carroll's attorneys, he recognized immediately that standard asset preservation orders would be inadequate because Trump had demonstrated both capability and willingness to restructure ownership through sophisticated corporate mechanisms. And let's be honest for a moment, federal judges issuing asset freezes that extend beyond property ownership to operational business entities and impose court monitoring of financial operations is extraordinarily aggressive. It does not happen because judges want to punish defendants or interfere with legitimate business activities. It happens when judges conclude that defendants are actively attempting to defeat judgment collection, and that only comprehensive restrictions will preserve assets pending enforcement. Here is what multiple legal sources say happened during the April 12th emergency hearing. Judge Kaplan began by asking Trump's attorneys to explain the purpose of transferring property management rights to newly formed Delaware entities in the weeks following the verdict. Trump's lead attorney, Todd Blanche, reportedly argued that the restructurings were routine business planning unrelated to the Carroll judgment. Judge Kaplan responded by noting that Trump Organization had operated these properties under consistent ownership structures for years and asking why sudden restructuring became necessary within weeks of a major judgment. When Blanche struggled to provide a business justification independent of judgment avoidance, Judge Kaplan stated that the timing and structure of transfers suggested they were designed to complicate enforcement. Meanwhile, Carroll's attorney, Roberta Kaplan, presented additional evidence obtained through subpoenas showing that Trump Organization had also begun transferring intellectual property rights, including trademark licenses and branding agreements to offshore entities registered in jurisdictions with limited cooperation with United States judgment enforcement. By the conclusion of the 3-hour hearing, Judge Kaplan announced from the bench that he would issue a preliminary injunction freezing assets pending further proceedings. The written order was filed 2 hours later and exceeded expectations in its scope and enforcement mechanisms. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. When the 142-page asset freeze order was filed at 3:47 p.m. on April 12th, Trump was reportedly at Mar-a-Lago meeting with campaign advisors to discuss fundraising strategy. According to sources familiar with the campaign operation, Trump's legal team had assured him that any asset freeze would be limited to preventing property sales and would not affect ongoing business operations. When attorneys called to inform Trump that Judge Kaplan had frozen all business operations and imposed court monitors with access to financial records, Trump reportedly became furious and demanded to know how judges could shut down his businesses over what he characterized as a ridiculous defamation case. That is when it became clear this is not another legal ruling that Trump can appeal away while business continues normally. The bombshell moment came in Section 7 of Judge Kaplan's order, which establishes the authority and responsibilities of court-appointed financial monitors. The order states that monitors shall have unrestricted access to all Trump Organization bank accounts, financial records, corporate documents, and communications relating to property management or asset transfers. The monitors are authorized to approve or disapprove any transaction exceeding $10,000, prevent any transfer of property interest, regardless of amount, and report directly to the court regarding any attempts to circumvent the freeze order. The order continues by noting that Trump Organization personnel must cooperate fully with monitors, and that any interference with monitor access or activities constitutes contempt of court, subject to sanctions, including incarceration. Reporters who obtained the full order immediately recognized that Judge Kaplan had effectively placed Trump Organization under court receivership for purposes of protecting Carroll's judgment. The order does not merely prevent Trump from selling properties. It gives court-appointed monitors operational control over financial decisions and requires Trump Organization to obtain monitor approval before conducting basic business activities. When federal orders require defendants to obtain court approval for routine business transactions and grant monitors unrestricted access to financial records, you are not watching standard asset preservation. You are watching a court assume supervisory control over business operations because the judge has concluded that the defendant cannot be trusted to refrain from hiding or transferring assets. This asset freeze sent shockwaves through business and legal communities simultaneously. When federal judges impose comprehensive business operation restrictions and court monitoring as asset preservation measures, it signals that enforcement authorities view the defendant as engaged in systematic judgment avoidance requiring extraordinary intervention. Claims that this represents judicial overreach become difficult to sustain when judges document specific asset transfers and corporate restructurings that occurred after judgments were entered and appear designed to defeat collection. This is not the first time courts have imposed comprehensive asset freezes on defendants suspected of hiding assets from judgment creditors. Think back to the Bernie Madoff case where federal courts froze all Madoff family assets and imposed monitors who controlled every financial transaction pending resolution of victim claims. The asset freeze extended to family members, associated entities, and offshore accounts. Monitors reviewed every proposed transaction and prevented any transfers that might dissipate assets. The comprehensive approach ultimately helped maximize recovery for defrauded investors by preventing asset dissipation during lengthy bankruptcy proceedings. Then there was the Enron litigation, where courts imposed asset freezes on former executives and required detailed financial disclosures to court-appointed monitors. The freezes prevented executives from hiding assets in family trusts, offshore entities, or through transfers to friendly parties. Court supervision ensured that assets remained available to satisfy judgments against individuals who had profited from corporate fraud. The president established that when defendants demonstrate willingness to use sophisticated asset protection strategies, courts can impose comprehensive restrictions that effectively assume operational control. Subscribe immediately if you have not yet. This content does not exist anywhere else. And let's not forget the pharmaceutical company litigation, where courts froze assets of Purdue Pharma and the Sackler family pending resolution of opioid settlement negotiations. The asset freezes extended to family trusts, offshore accounts, and corporate entities through which family members received distributions. Court-appointed monitors reviewed all financial activities and prevented any transfers that might reduce assets available for settlement. Now, however, Judge Kaplan has applied similar comprehensive restrictions to Trump Organization, treating it like courts treat defendants suspected of systematic judgment avoidance. The pattern is absolutely clear. When courts identify evidence that defendants are actively transferring assets to avoid judgments, judicial authority exists to impose restrictions that extend beyond simple property sale prevention to comprehensive business operation supervision. So, what specifically triggered Judge Kaplan's decision to impose such extraordinarily broad restrictions? According to legal experts who reviewed the order and analyzed the hearing transcript, Kaplan identified multiple indicators that Trump was implementing a sophisticated asset protection strategy rather than conducting legitimate business restructuring. The specifics matter enormously: the timing of corporate restructurings immediately following the verdict, the use of newly formed Delaware entities rather than existing corporate structures, the transfer of both property interests and intellectual property rights to offshore jurisdictions, the lack of legitimate business justification for restructurings that Trump Organization had not previously undertaken during decades of operation. These factors combined to convince Judge Kaplan that without comprehensive restrictions, Trump would successfully place assets beyond Carroll's reach. Here is why these indicators convinced Judge Kaplan that standard asset preservation measures would be inadequate. If Trump successfully transferred property interests through multiple corporate layers before freezes could be implemented, Carroll would face years of litigation attempting to pierce corporate veils and unwind allegedly fraudulent transfers. If intellectual property rights, including the Trump brand, were transferred to offshore entities, enforcement would require international legal proceedings with uncertain outcomes. If business entities continued operating and distributing revenue during appeals, assets would dissipate before final enforcement could occur. Sources familiar with judicial reasoning say Kaplan concluded that comprehensive operational freeze was the only mechanism that could actually preserve assets for potential collection rather than merely delaying their dissipation. Don't go anywhere. The most explosive part is coming next. And here is what should concern anyone who cares about whether court judgments can actually be enforced against defendants with resources to mount sophisticated resistance. This case is not just about collecting $83.3 million from Trump. If defendants can defeat judgments through strategic asset transfers and corporate restructurings conducted while appeals proceed, court judgments become symbolic declarations without practical enforcement value. Once that precedent is established, civil litigation loses credibility because prevailing parties cannot actually collect from defendants with legal sophistication and willingness to restructure assets preemptively. Future defendants would know that judgment collection can be defeated through sufficiently complex corporate structures implemented before enforcement procedures can be completed. This puts Trump Organization in an absolutely catastrophic position. On one side, business operations are effectively frozen with court monitors controlling financial decisions. The organization cannot pay distributions to Trump or family members. It cannot transfer property interests or intellectual property rights. It cannot restructure corporate entities or enter new business arrangements without monitor approval. Every transaction exceeding $10,000 requires court authorization. These restrictions make normal business operations functionally impossible and prevent Trump from accessing revenue from properties that have funded both his business activities and political campaigns. On the other side, the restrictions remain in place until Trump either satisfies the Carroll judgment or convinces an appellate court to reverse Judge Kaplan's asset freeze order. Appeals of such orders rarely succeed because appellate courts differ heavily to trial judges on asset preservation measures, particularly when trial judges document specific evidence of asset transfer activities. And here is the financial trap from which there is no easy escape. There is no viable path to lifting the asset freeze without paying the judgment. Trump cannot appeal the freeze to an appellate court with a reasonable chance of success because Judge Kaplan documented specific asset transfers that justify comprehensive restrictions. He cannot satisfy the judgment without accessing assets that are now frozen, creating a circular problem where he needs frozen assets to pay the judgment that caused the freeze. He cannot operate businesses normally to generate revenue for judgment payment because operations are frozen. His only realistic options are liquidate other unfrozen assets to satisfy the judgment or accept that business operations remain frozen indefinitely while appeals proceed through courts that typically affirm asset preservation orders. Legal scholars are calling this the most aggressive asset freeze imposed on a former president in American history. Jennifer Rogers, a former federal prosecutor now at Columbia Law School, told CNN that Judge Kaplan's order represents textbook asset preservation when dealing with defendants who demonstrate judgment avoidance behavior. She explained that courts have clear authority to impose operational restrictions when standard measures prove inadequate because defendants are actively moving assets. This is not judicial overreach or political targeting. This is proper exercise of court authority to ensure that judgments have meaning rather than becoming unenforceable declarations. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even legal experts, typically sympathetic to defendants, acknowledge the legitimacy of comprehensive asset freezes in appropriate circumstances. Alan Dershowitz, a prominent defense attorney, stated in a Fox News interview that while the restrictions seem severe, they follow established precedent when judges find evidence of asset dissipation activities. He emphasized that defendants who restructure assets after judgments cannot complain when courts impose restrictions necessary to preserve collection possibilities. When defense-oriented analysts acknowledge that asset freezes are procedurally proper, the judicial action falls within established authority, even if the scope is unusually broad. So, let's break down what this asset freeze means going forward. First, the immediate operational implications are devastating. Trump Organization cannot conduct normal business operations without monitor approval for every significant transaction. Property management decisions, vendor payments, employee compensation, lease negotiations, renovation projects all require court authorization. The administrative burden of obtaining approval for routine decisions will slow operations dramatically and may make certain business activities economically unviable. Some tenants and business partners may terminate relationships rather than deal with court-supervised counterparty, further damaging Trump Organization revenue. Second, this creates enormous pressure to satisfy the judgment quickly. Trump must either liquidate unfrozen assets to raise $83.3 million or accept that business operations remain frozen indefinitely. Financial analysts estimate that Trump has sufficient unfrozen assets to satisfy the Carroll judgment if he liquidates golf courses, licensing agreements, or other holdings not covered by the freeze order. However, forced liquidation yields substantially less than market value because potential buyers know Trump is under pressure. Even if Trump can raise the necessary funds, the reputational damage from having business operations frozen by court order may affect future business relationships and political fundraising. Finally, the precedent implications extend beyond Trump's specific situation. The Carroll case demonstrates that prevailing parties in defamation litigation or other civil cases can obtain comprehensive asset freezes when they present evidence that defendants are transferring assets to avoid judgments. This will embolden other judgment creditors to seek similar relief when dealing with sophisticated defendants. Future litigation may see more frequent use of forensic accounting to track asset transfers and more emergency motions seeking comprehensive freezes. This fundamentally changes the landscape of judgment collection against wealthy defendants who previously could use corporate restructuring to delay or defeat enforcement. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate business and financial ramifications, this is really about whether the civil justice system can enforce judgments against defendants with resources to implement sophisticated asset protection strategies. If defendants can defeat judgments through corporate restructuring and offshore transfers conducted during appeals, court decisions become advisory opinions without enforcement value. Courts must be able to impose comprehensive restrictions when evidence shows defendants are actively attempting to place assets beyond creditor reach. This scenario is causing absolute crisis within Trump Organization and among Trump's business advisors. Reports indicate that executives held emergency meetings throughout Wednesday evening, trying to understand how to operate under court monitoring. Some argued for cooperating fully with monitors and seeking approval for essential transactions to maintain basic operations. Others insisted that cooperation validates the freeze order and that Trump should challenge every aspect through appeals and motions. The organization is fracturing over whether to work within the restrictions or fight them comprehensively, despite low likelihood of appellate success. Meanwhile, Trump himself has responded with characteristic fury. He released statements calling the asset freeze illegal government seizure and claiming Judge Kaplan has no authority to shut down his businesses. He characterized the restrictions as election interference designed to his campaign by cutting off business revenue. Trump specifically attacked Judge Kaplan as a biased activist judge who should be removed from the case. He declared that he will appeal the freeze order immediately and predicted quick reversal by higher courts. Stay with me? What comes next will completely change how you view this situation. Here is what makes Trump's defiant response so counterproductive from a legal and business standpoint. By publicly attacking Judge Kaplan and declaring the freeze order illegal, Trump is creating a record that could be used as evidence of non-operation if monitors report compliance problems. Courts impose additional sanctions on defendants who publicly characterize valid court orders as illegal and encourage non-compliance. Trump's statements may eliminate whatever flexibility monitors might have shown regarding marginal transactions by signaling that Trump views the entire process as illegitimate. Legal experts immediately warned about the risks of Trump's confrontational approach. Pitt Parara, former United States Attorney for the Southern District of New York, pointed out that defendants who attack asset freeze orders publicly while subject to those orders typically face contempt proceedings when any compliance issues arise. Courts cannot allow their orders to be publicly characterized as illegal without consequences, or judicial authority becomes meaningless. Trump's response virtually guarantees that monitors will report any questionable activity to Judge Kaplan, who will be primed to impose sanctions. This goes far beyond one asset freeze in one case. It is about whether the civil justice system can function when powerful defendants refuse to accept court authority and rally political support for resistance. If defendants can ignore asset preservation orders by characterizing them as illegal seizures and calling on supporters to view enforcement as persecution, the judicial system loses ability to preserve assets for judgment collection. It is not just about collecting money from Trump. It is about whether courts can maintain authority to impose and enforce asset preservation measures when defendants have political platforms to attack judicial legitimacy. If this blows your mind, hit that like button right now. Here is the situation. A federal judge has frozen Trump Organization operations and imposed court monitors with authority to approve or disapprove all transactions exceeding $10,000. The freeze remains in place until Trump satisfies the $83.3 million Carroll judgment or obtains appellate reversal. Trump has publicly characterized the order as illegal and vowed not to comply. Contempt proceedings appear likely if compliance issues arise. When federal judges impose comprehensive asset freezes with operational business restrictions and court monitoring, they have concluded that defendants cannot be trusted to refrain from dissipating assets and that extraordinary measures are necessary. There are no consequences for transferring assets to avoid judgments. Civil litigation becomes meaningless because defendants simply restructure ownership before enforcement can occur. Future defendants would know that judgments can be defeated through sufficiently complex corporate structures implemented while appeals proceed. keep a close eye on compliance reports from court-appointed monitors. Monitors must file monthly reports detailing Trump Organization financial activities and any compliance issues. Judge Kaplan will review these reports and has authority to impose additional restrictions or sanctions if monitors report problems. And business partners, lenders, and political donors are watching to see whether Trump Organization can function under court supervision or whether the restrictions make ongoing operations unviable. Before we go any further, smash that subscribe button so you never miss content like this. Here is where things stand right now. Trump Organization operations are frozen pending judgment satisfaction. Court monitors control financial decisions. Trump has publicly attacked the order as illegal. Monthly compliance reports will reveal whether operations can continue under restrictions or whether business relationships collapse under court supervision. This is not just another legal setback that Trump can appeal away while continuing business as usual. This is operational freeze that has already occurred with court monitors assuming supervisory authority and comprehensive restrictions preventing normal business activities. What happens next could determine whether civil court judgments can be enforced against sophisticated defendants who attempt asset protection strategies, or whether corporate restructuring can effectively defeat judgment collection regardless of judicial orders. The freeze has been imposed, the monitors have been appointed, the restrictions are in effect. Now, we wait to see whether monthly compliance reports show Trump Organization operating under court supervision or reveal compliance problems that trigger contempt proceedings and additional sanctions. The stakes have never been higher for judgment enforcement credibility. The restrictions have never been more comprehensive, and the business consequences have never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.